Very warm good evening to all. Today's topic is about 125 section under Criminal Procedure Code. There are many sections under Criminal Procedure Code, but this is something which is really related to the society completely. The reason behind that, it touches the basic part of the life every day, that is food, shelter and clothing. Now here 125 Cr.P.C, as we all have read, it speaks about the maintenance for the wife, for the children, and for the parents. Now, it is actually very simple, and I would say in all the maintenance laws, this is a simple law. You can really utilize the same for your clients' purpose and get the required order, because the highlights I am going to share with all of you here in after as the session progress, you will find that this is the simplest thing we can do, because the execution is also very easy. Under civil law, with all due respect to that, all the other laws, I have always found that Cr.P.C 125 is very easy to execute the orders also. And it is also a summary trial. So it's very easy to get it over fast, like to get easily the earliest the orders for your client. Secondly, it also comes with lot of restrictions, and it also recognizes the other laws, that is personal laws of the, that is Hindu and Muslim laws, which we will be discussing with the help of some judgments. Now here, what is 125 Cr.P.C? Basically, it is the maintenance awarded to the wife, and here a wife includes divorced wife. Always remember that. See, definition does not exclude the wife who has been divorced. There are exceptions of the Muslim wife. I'll come to that. And also there is one more important thing. Even the parents can demand from the daughter as well as son the maintenance. And the children who have not attained the majority. Now, the children who have not attained the majority, there are some exception to that also. But before we go to that, I will highlight some of the very important features of this 125 Cr.P.C, which actually, if you read the sections, there were amendments, but if you find the old barracks, you will not find this. Now, the first thing I would like to tell all of you, which is very interesting here, is the quantum. If you read this section, you will find it is 500, then it will increase to 1500. But later on, now there is no ceiling. So it is as per the standard of the respondent, that is against whom the case we have filed. It may be husband, it may be a son, or it may be daughter. Also, now we go to the there is a no strict proof of marriage required for 125 Cr.P.C. Now, this can be a matter of debate. Still, I would say, if you go and file for divorce, the court say, first show me the proof that you are married. In Family Court Mumbai, normally they request for two proofs of the marriage. One is the photograph, that is wedding photo. Another is the either wedding card or the certificate of the marriage. If it is not available, then we have to give the affidavit of some relatives who has attended the marriage, maybe parents or somebody who is related. So it is really difficult, but under 125 Cr.P.C, if the clients are able to show that for a long period they have stayed together as husband and wife, then actually 125 Cr.P.C is applicable to them. Now, always remember that strict proof of marriage does not mean, if it is not required, that it will include the live-in relationship. Now, the live-in relationship is totally different. That is actually described and completely explained by the Supreme Court in the Veluswamy judgment, which has given 4 conditions, which we can discuss some other day. That these are the things for live-in relationship also, and that is not recognized live-in relationship. The word used in Domestic Violence Act is any relationship in the nature of marriage. So that topic is not of today, but here when I say the strict proof of marriage is not required, that does not mean that anybody who is not married can come and ask for maintenance. The law, the legislature want to say that any two people, male and female, have stayed together for a longer period and they have begotten the children or not. If the lady continues to stay with him and they have posed themselves as a husband and wife to the society, there may not be Saptapadi if they are Hindu. If they are Muslim, possibly she may not have nikah nama, anything. That is also possible. There may be something which just they have to show that they have stayed together. Now, how do we find that? There may be LIC policy where a nomination is there. There may be a Aadhaar card in recent times. There may be a bank account where her name may be there or joint account. There may be a property. So you have to prove that somehow they were together as husband and wife, though you may not have the strict proof. Now, next is that is the second wife included? I would say, and completely with all the faith, the second wife is not included. Yes, there are some judgments which say the second wife has been awarded maintenance, but these are just, we can count 1, 2, 3 on our fingers. They are not more than that. And the basic thing which I have noticed, that second wife has got the maintenance only in the situation where the first marriage was concealed by the husband. So underline this point, that where the wife was not aware that the person is already married. So second wife does not include. It only includes divorced wife and the wife legitimate. Also, there are legitimate and illegitimate children. Now, legitimate children is of course born from the marriage, from the wedlock, but some children who may have begotten from the second wife. And in such situation, if she is a mistress or some other relation, she may not be entitled to the maintenance, but her children will be entitled to the maintenance. So therefore, it is called social legislation, which is taking the giving support to the children who had no role in such marriages, and they were born without any legal, I would say, there was no legal task or legal something. They are born out of the wedlock. So such children are also protected, and parents are protected. That is one more thing. Now here next is, there was no interim maintenance word in the beginning, but as the amendment happened, now interim maintenance is also granted in 125 CRPC. Also, the maintenance after the Rajneesh versus Neha, the Supreme Court judgment, everybody knows, from the date of application. If you read this section, it will say either from the date of application or from the date of order. But nowadays, it takes a lot of time in the court. So it will be from the date of application. That is also one good feature of this 125 section 125 CRPC. Also, the order copy will be given free of cost. Sometimes as a lawyers, we are also not aware, with all the due respect to all the lawyers here, that we are not aware that the order copy will be given free of cost to the lady or to the parents or to the children, those who have got the order in their favor. So always remember the order copy is free. Sometimes we are paying charges and we are asking the certified copy. The order copy will be free. Now next, the interim maintenance has to be granted within 60 days. That is what the law says. It is possible that the court may not have time, but still you can point out, with all due respect to the court, that interim maintenance may be granted within 60 days. The law says that it should be granted within 60 days. Then one more important thing, if there is arrears, the husband is not paying to maintenance to the past, to the wife, to the children, then for arrears, you have to file the application for execution. That is within 1 year, in 12 months. If you do not file within 12 months, the limitation goes, and really it is very difficult unless you are able to show the reason, like pandemic now we have. You have to able to show some authentic reason, the real reason. There was a reason for the delay, and delay may be condoned. So it is only 1 year. Within 1 year, you have to clear the you have to get the arrears clear. Otherwise, this maintenance will go away, and the wife or the petitioner who has got the maintenance may not be allowed to recover the same. So it is very important. Sometimes we get the maintenance pass, but then the period of limitation for recovery of arrears is only 1 year. Now, again, we can go to the 125 CRPC. As said in the beginning, it is applicable to the wife, to the children, and the children will include, it will include the legitimate, illegitimate, as well as adopted and stepchildren as well. Secondly, there is a possibility that the children may attain the age of 18. Once they attain the age of 18, they will not be able to ask maintenance under this 125 CRPC, because it clearly specifically says that only till they attain the majority as per the Indian Major Act, that is 18 years. Now here, there are some children who are physically unable to maintain themselves. There may be somebody, they may be physically challenged or mentally challenged. There is one more word used by the legislature, that is injured. They are injured, and this injury can be mental or can be physical. We have a very beautiful judgment. I will be discussing as the session progress. So the three words, the exception to the, even after children attains the majority, is that if there is a physical or mental or challenge to these children, or there is an injury, and this injury may be mental or physical, and they are unable to maintain themselves, then they will be still entitled to the maintenance under this section. Now this section also further says that the wife has to show that there is sufficient cause to stay away from the husband. If she is unable to show there is sufficient cause, then she may not be entitled to the maintenance. Also, if she is living in adultery, then also she may not be entitled to maintenance. After divorce, she remarries, her maintenance will be stopped. Then also her maintenance will be cancelled. So these are the things. So 125 itself is a very exhaustive section. And it is very clearly mentioned, and the judgments are, that's why you will find very few judgments on 125 CRPC, which is saying something different than the legislature what it has been enacted. Now, next we go to some important judgments. First, I would like to take you through one very important judgment, that is K. Vimal versus K. Veeraswamy. Now, this judgment is written by Justice Fatima Bibi. She was, if you all remember, she was the first lady judge of the Supreme Court. She was elevated, the first lady, and she has written this judgment very beautifully, and she has tried to say that why 125 CRPC was brought by legislature. As said in the beginning, Fatima Bibi has said that it's a social legislation, and to stop vagrancy, and also that these wives and children, if the husband goes and marries somebody else and he produces these children, they should not be left as destitute. वो निराश्रित नहीं होने चाहिए, किसी पे आश्रय नहीं होने चाहिए. And this was the reason behind this. This judgment says that this social legislation was brought in to help the children and the wife who has been left by the husband without any really actual reason, without any reason. So this K. Vimal versus K. Veeraswamy is a very, it is of 91 and of Supreme Court judgment. And before, whenever we draft 125 CRPC, I would like to request all the lawyers here, do read this judgment, because it is really helpful to understand why 125 CRPC was enacted. I won't say it has let down the law, but this judgment, I found that it has been cited many times thereafter, even after 90s, and the basic idea behind that there should not be vagrancy and the destitution in the society. In that way, section 125 CRPC is called social legislation. Now, next judgment, we will go to Babita Bist versus Dharmendra Singh. This is of recent judgment of Delhi High Court of 2019. Now, in this judgment, the wife was awarded 30% of the gross income of the husband in the beginning. However, later on, it was reduced to 15%. The matter was carried to the Delhi High Court, and Delhi High Court said that the quantum of maintenance should be such that the wife can live with the dignity. She should enjoy the same standard of living and the same similar to what she was enjoying at her husband's place in her matrimonial home. So she should be given a maintenance with which she can actually live with the same standard wherever she is living with her parents or wherever she wants to stay. So it should be 30%. So roughly I would say it is saying that 1/3 of the maintenance should be granted to the wife. This is what it is saying. So she is entitled to lead a good life, and this judgment is again something which can be utilized for other in other Hindu law as well as the other matters, where you can say that 1/3 of the judgment, 1/3 of the husband's earning can be given to the wife. There are some two judgments of the Supreme Court is also mentioned in this judgment. Now next is we go to the another judgment, that is Amod Kumar Srivastava versus State of UP. Now, this judgment, two beautiful things are actually explained, which are very important for all of us to understand. One is that if the children are major, now here there were two daughters who were actually major. Are they entitled? They were Hindu, being Amod Kumar's daughter. Are they entitled to maintenance even after 18 years? The law said no, they cannot ask the maintenance. But in such situation where they are unable to maintain themselves, maybe because they are studying or they are unable to get some job, then what is they supposed to do? Are they going to starve because the father is not supporting? The law say no. Because they are protected by the personal law, that is Hindu law, they can very well go under Hindu Adoption and Maintenance Act until her marriage, that is the unmarried daughter, is allowed to take shelter under the Hindu Adoption and Maintenance Act, and she can demand maintenance from the father to maintain herself under the Hindu Adoption and Maintenance Act, that is the unmarried daughter. There is also one more judgment of the Supreme Court, Abhilasha versus Prakash, which is also very clearly says that under 125 CRPC, the major daughters are not entitled to get the maintenance. Now, what happened if, before we go ahead, I would like to discuss one more point, which was discussed in Amod Kumar Srivastava case. That is restitution of conjugal rights. Now, what happened when the wife files for the maintenance, simultaneously the husband may file for the restitution. Now, this is a big myth that if the husband calls the wife to stay back, he will not be asked to pay the maintenance. Actually, that is not true. But when restitution decree is passed in favor of the husband and the wife is not ready to go, then there is a possibility that in Amod Kumar, 3 judgments are mentioned. One I would discuss with you, that is Balram Dash versus Srimati Gitanjali. Actually, it is Das, but DSH, the spelling is Dash. This judgment, these 3 judgments, that if conjugal rights decree is passed in favor of the husband and wife is not ready to join the matrimonial home without any sufficient cause, then she may not be entitled to the maintenance. So restitution of conjugal decree is also useful to you, but then because it should be used in genuine cases. There are cases which says Merunisa's case, which is again saying that some people, some husbands may be using this decree not to pay the maintenance, but then the court will be vigilant enough to check really why the wife is not going. So there are 3 more judgments. One is of the Balram Dash. So even after restitution of conjugal rights decree is passed and wife is not ready, then she may not be entitled to maintenance under 125 CRPC. Now, what happens to the Muslim daughter who is unmarried? Now, 125 CRPC says that she cannot ask, or for that reason, any girl, our gender neutral, it is 125 CRPC, Any unmarried daughter who has attained the age of majority cannot ask the maintenance under 125 CRP. Major children are not entitled. Now, Merunisa's judgment is a very revolutionary judgment. It is of Justice Phanindra from the Karnataka High Court of recent 2014. Now, this judgment says she will be entitled. Now, see how the legislature is interpreted. I will read para 56 from this judgment to benefit all of you. Applying the above said principles to the facts of the case on hand, the Mohammedan daughter who has got a right to be maintained by her father under Muslim personal law, as already noted above, the infringement of such right of that lady itself amounts to an injury which can be very well be equated to the word injury used in section 125C of CRPC. Physical or mental abnormality has to be established before the court of law by means of evidence. But the mental or physical injury as already narrated above. Physical injury can be perused by the appearance or by means of senses. But mental injury it is nothing but malice in law, which can be gathered on the basis of violation of a legal right to claim maintenance vested under any law for a time being in force, including section 125 CRPC. If such right is infringed by the adversary, then automatically it will fall under section 125C of CRPC. The other riders which are there in the said provision is also have to establish that they are unable to maintain themselves, has to be strictly complied. If that right to claim maintenance of that lady is infringed, definitely it can be called as an injury, which can very well be fit into definition of mental injury. And in my opinion, that must have been the intention of the legislators and the parliamentarians in introducing the word injury under section 125C of the CRPC. Now we go to the 125C of the CRPC. 125 CRPC 1C is his legitimate or illegitimate child, not being a married daughter who has attained majority, where such child is by reason of any physical or mental abnormality or injury. See, it is saying physical or mental abnormality or injury, unable to maintain itself. Now, here, Justice Phanindra from Karnataka High Court in Merunisa's case versus Syed Habib has beautifully interpreted that the word injury, anybody, any father who is not ready to maintain his children, it may include the unmarried Muslim daughter. The word used is the injury. So it will also amount to a mental injury. See, the cruelty is not defined anywhere. Now, anybody who is not paying maintenance to the child or unmarried daughter, who is now 18 years, 19, she may be in college. If she is not given, then it may cause some mental trauma to her, which is mental injury, which cannot be counted, which cannot be seen. So this judgment, I would say, very revolutionary judgment, which says that under this sections 125 CRPC, the Muslim daughter will be entitled to the maintenance. So I found this judgment very useful to be shared with all of you. And one more judgment, which is discussed by the Supreme Court, that let me see here if it is not mentioned in Amod Kumar also we can see. Abhilasha versus Prakash, that is what we have discussed actually, which says that she will not be entitled. Now here the Hindu daughter will not be entitled. Now the law says that the Supreme Court, till now whatever has happened in the law, the Supreme Court has never got a case where a Muslim unmarried daughter has gone up to the Supreme Court. So it was not a point of discussion there. So Merunisa has actually discussed that Supreme Court has not got that situation where they have to discuss the unmarried Muslim daughter will be entitled for the maintenance or not. So Merunisa judgment is actually a very big help to all the Muslim daughters to help so. And Abhilasha versus, now just a minute. I would like to read one more judgment, that is of the Kerala High Court here. Para 16 from the Merunisa judgment. In this regard, the learned counsel for the respondent relied upon decision of Kerala High Court reported in 2003 between Muhammad and Kunaiya. Now here, wherein the Kerala High Court had in detail dealt with provision of section 125 Cr.P.C with reference to the above referred Supreme Court judgment. Now here, the Supreme Court judgment is, that is of Noor Sabah Khatun versus Muhammad Qasim. Here the children were very young and they were minor. So Kerala High Court has relied upon this judgment, but Merunisa judgment says that the children were minor and there was not unmarried daughter who was actually major. So the Justice Fanindra actually interpreted that the word mental injury has to be interpreted in such a way that a father who does not maintain his daughter, who has not married and who is though major, is unable to maintain herself, and if the father is not paying in maintenance, it will amount to mental injury, and that is the reason in this way it was interpreted to pay maintenance to her. So Merunisa judgment is one judgment where we can take the help to get maintenance for the unmarried Muslim daughter who is actually major. And this judgment can be used in other way also. But for Hindu daughters, I would, unfortunately, I would say Abhilasha versus Prakash is an embargo which says that you cannot ask. But same time, there is under Hindu law, we find a judgment and also the Hindu Adoption and Maintenance Act, which says the unmarried daughter under section 20 can ask for the maintenance, and it's her absolute right. And in fact, even she can ask her marriage expenses also. So this was all about today's